There are three major motions hearings that you will see in criminal court in Louisiana. The first one is a preliminary hearing. A defendant has the constitutional right to a preliminary hearing provided he was not indicted. The indictment serves as a finding of probable cause. In all other felony cases, the defendant has a right to have the district attorney present evidence and have the judge decide if there's probable cause. So what happens if the judge finds there's no probable cause? Well, then that person is relieved of their bond obligation. So if they are in jail, they are released. If they're out on bond, but they have special conditions like an ankle monitor or there's private supervising probation officer, they don't have to worry about that anymore. Now, in some states, if the judge finds no probable cause, the case is over with. That's not the situation here in Louisiana. Louisiana, the district attorney can still prosecute you, still bring you to trial regardless of what the judge's decision was in that regard. It should be noted that there's no right to a preliminary hearing in misdemeanors, so just put that out there. The next type of hearing, the second type, is a suppression hearing, and this is where you move to suppress physical evidence, where you move to suppress any confessions, where you move to suppress any photo lineups or identification procedures. These all deal with your fundamental constitutional rights found in the 4th, 5th, and 6th Amendments to the United States Constitution. Was there a valid warrant? Was there an exception to the warrant requirement? Was your confession a free and voluntary act? Was there any identification procedures too suggestive? Those are all the types of areas of inquiry for those particular topics. If the judge suppresses the evidence, in some cases that means the district attorney has no evidence to present and your case will be dismissed. In other cases, the district attorney will still have enough evidence to go to trial, but they go from it at a different tactic at this point because they have less evidence. And in those situations, sometimes you can negotiate a really favorable resolution for your client. The third type of major motion that you will see is a motion in limine. That just means a motion to limit. It's Latin. And basically you seek to exclude evidence, not because it was unconstitutionally obtained, but there's some other evidentiary reason to exclude it. Generally it's too prejudicial or it's hearsay. So a common example is in a murder case, the district attorney likes to show autopsy photos where the person's cut open, you see their brains, their organs, and it's disgusting. And they say, oh, we're gonna use it to show the person's dead. Well, no kidding. So the defense attorney will say, hey, look, this is too inflammatory. They don't need to show the open cranium with a brain on the table to show that the person's dead. There's another way to do it. It's too prejudicial. That photo excluded. Sometimes if you think that there's going to be some hearsay that comes into trial, you'll file a motion in limine for a pretrial ruling to say, hey, I don't want this coming in. Now, any of these issues in the motion in limine could be raised as regular objections at trial, but it's all going to be done in front of the jury. And as a tactical reason, you don't want the jury saying, why does that defense attorney not want me to see all the evidence? So it's good to get those things out in the open early so you can have pretrial rulings and everyone can know the groundwork for the trial.